I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Roquan. Constable, your client waived the formal reading of the indictment. Ms. Vargas, in cause number 26, DCCR 0081, the state has elected to proceed on count 1 only. It alleges that you committed the third-degree felony offense of harassment of a public servant from July 11th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablets some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Roquan? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Yes. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Yes. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Vargas is not competent?
No, Your Honor.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. All right, good luck to you, ma'am. You go back to the bailiff. Good morning. Are you Quentin Sells? And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026. Also, it is from a Dr. Shahani. Also has the same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated May May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency? Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill, and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, next time we are in court, if we are in a similar situation, the state will reconsider.
Okay, perfect. I know there's some civil, locally, civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we're going to go forward that time. So you're going to go back to an hospital, follow all of their rules, okay, so that you can get better, take your medicine, and we'll see if we can get your case taken care of. Right, I think the doctors still think they think you need a little more treatment so that you understand all of your legal proceedings, okay? All right, you can go back with the bailiff. Mr. Rojas will visit with you. Thank you. I don't think there's any expectations of restoration. There's more of an issue. So you might take a look at it.
Yes, sir.
Okay.
No, next time.
Johnny Sagita. Charged with a second-degree felony offense of burglary of a habitation from April 21st of 2026. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up the right to appeal? And it looks like the agreement that you reached is for a cap of 10 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at the sentencing hearing. But as long as I stay with you, Byron Jamal Morris.
Yes, it will.
And Mr. Rojas, will your client waive the formal reading of the motion? Mr. Morris, in clause number 15-21651, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 21st, 2016 for the second-degree felony offense of burglary of habitation, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of public intoxication November 6th of 2025. And is that true or not true? Count 2 alleges that you failed to report to the Jefferson County Probation Department for your administrative hearing December 18th of 2025. Is that true or not true? Count 3 alleges that you failed to comply with the curfew and that you were outside of your approved residence at approximately 11:59 p.m. November 6th of 2025. And is that true or not true? Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. Is that true or not true? Count 5 alleges that you're behind in your court assessed fees as of January 14th, 2026 in the amount of $7,711. And is that true or not true? Did you enter your pleas of true to counts 2, 3, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablets a document that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a cap of 5 years in prison. Is that your understanding? State tenders number 1.
No objection. Anything that you think is important for me to know, make sure you get that to Mr. Rojas, and he'll present it to me on your behalf when you come back. Okay, you can go back with the bailiff. Thank you, Judge.
Thank you. I should show that it was reset. That's okay. Okay. Mr. Lewis, you've got Avriona Dorsey.
I think I need to sign that, Your Honor.
Okay, I'll call it as soon as she's ready. Do you need? Oh, she's already doing another one. About Kenneth Harrison. Mr. Lewis. Morning. How are you? DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first-degree felony offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct? The motion alleges that you violated your probation Count 1 alleges that you failed to report as directed on or about March 31st of 2026. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, in and 5, 6, 7.
Count 7, just wait a minute. Count 7 alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true? person for aggravated robbery with 3 guns in that car, another gun in this car. If he got 8, then I would consider that, but at this point,
We'll discuss it.
I'm over all of this gun stuff, so I'm gonna, I'll keep, I guess, the paperwork for now. If y'all come up with an agreement, otherwise, it's motion to vote. I don't know if any agreements can just be up to me, and if you have a hearing, we have to. But I'll just keep it for now, and make an adjustment, Mr. Smith, if you'll step in front of the clerk first real quick so she can, swear you in and take the, thumbprint. Supposed to be ISF substance. Oh, okay. Is there any evidence that Mr. Smith is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department gets your pre-sentence report. And I'll give you more information about you and your case. We'll make sure that you have everything in place, in addition to safety. I mean, client setup that you need in order to be successful. And then we'll come back for sentencing and all that. All right, you can go back to the bench. Okay. Let's do
Victoria Bailey for
let's do Victoria Bailey. It's a sentencing.
Victoria Bailey. Mark Hebert, we're just gonna go through the motion.
Okay. Thank you. Good morning, ma'am. Are you Victoria Bailey?
Yes, ma'am. Good morning.
And Ms. Bailey was previously here in court in cause number 25 DCCR 0278, entered a plea of guilty to the third-degree felony offense of assault on a hospital personnel. And I received that pre-sentence report, and you both had an opportunity to review the report.
Your Honor, question.
Are there any additions or corrections?
Nothing more than that.
All right, Ms. Bailey, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include being on the specialized mental health caseload. And I'll make sure you have anything you need in order to be successful. So you can get your getting drug treatment, mental health treatment, and it's important that you follow through with everything that they recommend. Even if you don't think it's necessary, it's going to be court ordered that you go through whatever program probation says you need to, okay?
Yes, ma'am.
This is a great opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have a felony conviction. So it's a great opportunity.
Yes, ma'am.
The other side of that opportunity, though, is that if you violate any condition of probation, you can be brought back into court and you can be found guilty and sent to the prison for between 2 years and up to 10 years. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. It looks like I will be signing also a dismissal in cause number 25 DCCR 0170 as part of that agreement. All right, good luck to you, ma'am.
Thank you. Thank you so much.
corrected on January 12th of 2026 and December 16th of 2025, and is that true or not true? Count 3 alleges that you failed to report to your administrative hearing that was held on February 2nd of 2026, and is that true or not true? Count 4 alleges that you failed to work faithfully in suitable employment and provide verifications thereof, is that true or not true? I mean, you look at your
He's self-employed, and he's had a business for a while that was slow. He's part of the hesitation is he's had some serious health issues. That's why
Yeah, I think
that's why it's about
So you don't have to say true just because you're here. So is it true or not true that you failed to work faithfully in suitable employment and provide verification? Count 5 alleges that you failed to submit to alcohol or drug screening January 29th, January 23rd, January 21st, January 13th, and January 9th of 2026. And is that true or not true?
Yes, ma'am, true.
You did all these dates backwards
I
on
know.
this one. Count 6 alleges that you failed to comply with the program guidelines and rules of JCDI program. Is that true or not true?
True.
Count 7 alleges that you are behind in your court assessed fees as of February 2nd, 2026 in the amount of $168. Is that true or not true?
Pretty sure I've paid up on that.
Okay, be not true on 7. Count 8 alleges that you provided a urine sample May 11th of 2025 and April 13th of 2026 that tested positive for marijuana. Is that true or not
True.
true? Count 9 alleges that you provided a urine sample May 11th of 2025 that also tested positive for methamphetamines. Is that true or not true? And count 10 alleges that you provided a urine sample also May 11th and it tested positive for alcohol. Is that true or not true? All right, did you enter your pleas with true counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily?
Yes.
The ones that you pled true to, did you plead to those freely and voluntarily? And did you plead true to those because they're mutually true? All right, then I'm going to find that you entered your pleas with true to counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily. Find those counts true. for them to bring Donald DeRusso. Donald DeRusso. Donald DeRusso.
call him Duracell.
DeRusso. DeRusso.
I don't know if it's right. He answered. Again, she's already emailed
Thank you. See, are we going on count one only?
it. Yes.
That's fine, the judge's priors make him habitual by law, but he didn't proceed even half the time he is on this case.
All right, so are you Donald DeRusso? And we'll waive the formal reading of the indictment. Mr. DeRusso, on cause number 26, DCCR 0758, you're charged with the state's going to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 9th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablets documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. DeRusso is not competent?
No, you're not.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bail. Oh, wait, and I am making an affirmative finding of a deadly weapon. All right, you can go back with the bail. Mr. Lewis, you've got Ariana Dorsey. agreement and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing. All right, you can go back with the bailiff.
Judge, I think we're ready to go. 7, 8, Mr. Harrison.
All right, Kenneth Harrison, thank you. Oh yeah, we already went through. Okay, we're back on the record with Mr. Kenneth Harrison at 24 DCCR 0544. Mr. Harrison had already entered pleas of true to counts 1, 2, 3, 7, and 8. And you guys have visited, I guess, about my unwillingness to accept the plea agreement and to come up with some other agreement.
Yeah, sure, we have
And what is that?
right here.
And Mr. Harrison, is that your understanding and is that your agreement? And so with everyone's permission, can I make that modification of the agreed punishment regulation? You said no? Oh, I thought he said yes.
Yes.
He said yes.
I heard it wrong.
That's okay. So, we can make that a modification on these documents. So I have here, Mr. Harrison, on the tablets, documents that have your signature on them. I've made that change to show that the agreement is for 8 years instead of 5. Before you went over and signed these, did you go over them with Mr. Lewis? Do you fully understand all the documents you signed? And do you understand if I follow this agreement that you will be waiving or giving up any right to appeal? State tenors number 1. It's admitted. Is there any evidence that Mr. Harrison is not following? Alright, sir, I'm going to find that you entered your plea true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. Again, making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition can lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk to Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and possession of a firearm while you're on probation. So, Mr. Reddo, probably what's going to happen today, based on the information that I've received from the district attorney's office, is that that motion to revoke your probation is going to be dismissed. This is the second time that you're kind of getting away with doing something that you probably shouldn't. I want you to understand, at this point, I'm going to order that you are on zero tolerance on your probation, that you will be on the high medium caseload and required to do everything that you're supposed to be doing. If you are caught with a firearm, if you're around anyone with a firearm, I don't care who it belongs to, ownership, if you're around it, it is going to be a violation of your probation. I'm ordering a condition of your probation is that you are not allowed to be around or in possession of a firearm in any way. Not in the same house as one, not in the same car as one, period, none. So there won't be any question if there's an issue that keeps popping up here with regard to firearms, that if you're around one, it won't matter whose it was or whose it belongs to, it's going to be a violation. And it's not going to get dismissed, you're going to end up in prison. Do you understand? You're on a very serious probation, and I have some concerns about what's going on. But you're back on that probation, you still have the same opportunity to be successful. It's going to be up to you to quit doing whatever it is that's going on. Okay? If you have an issue with whoever it is that you're dating or married, then you need to get away from that, because that's going to end up getting you in more trouble, right? Okay, you can go back with the bailiff. Angela Reyes. What? Are these the three she's playing on?
Yes.
Okay. Thank you. That needs to be.
Oh,
Good morning, ma'am. Are you Angela Reyes?
Yes.
And will your client waive the formal reading of the indictment in each case?
she does, she does.
Ms. Reyes, you are Angela Reyes, correct?
Yes, ma'am.
And Ms. Reyes, in cause number 26, DCCR 0265, you're charged with the third-degree felony offense of obstruction or retaliation from December 22nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes.
And then in cause number 26, DCCR 0787, you're charged with a second-degree felony offense of assault on a peace officer. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0788, you're charged with a third-degree felony offense of harassment of a public servant. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes.
In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreements that you've reached in these three cases would be for you to receive 10-year deferred probations in each case. There would be fines in each case of $1,000. You would be ordered to
Your Honor, I'm sorry. I don't know if it was the intent of the state to have a total
Three.
$3,000 fine. I'd be willing to waive the fine on 2 of those cases and just have.
So a
the
total of
$1,000.
$1,000 fine in, let's just put it in 0265,
Yes.
and there would be no fine in 0787 and 0788. Is that your understanding?
Yes, ma'am.
Is it also your understanding that you would submit to a mental health evaluation and follow any and all recommendations and treatment beyond that mental health caseload at the probation department? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Reyes is not competent?
No objection.
All right, ma'am. In each of these cases, and also part of the agreement is that the state would dismiss all of the other remaining cases. Is that your understanding?
Yes.
Then I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient